Welcome to the fifth meeting of the Finance Committee in this members. To remind people, the committee, this will be broadcast online and throughout Parliament buildings. If you're on mobile devices, put them on airplane mode and silent. Not permitted to take photographs or record anything in this meeting. As always, apologies. We have apologies from Steve Aiken. Yeah, okay, and we have everyone else. Next item is declaration of interests. So just asking whether, if members have any relevant interest they want to declare at the start of the meeting per today's agenda. Okay, in that case we'll move on. Agenda item, well actually we're going to do, I think, chairperson's business at the end.
Well, Chair, if we do chair's business and matters arising after the Fiscal Council, that means we can spend more time on these briefings prior.
Exactly, and there might be one or two things people want to discuss in chair's briefing. We might have questions, or and I might have one or two things to add to it. So I think it's probably better if we leave that until after our evidence sessions, so that way we can get through, because we know we're going to be ending our evidence sessions at 4. We have a hard stop then. Item 4 is draft minutes of the 20th of February meeting. That is on page 14. So members, is everybody content? Any issues with the minutes of the last meeting? Everyone's content, I'll sign the minutes. Okay. We'll do matters arising, I think. Will we do matters arising at the end, or do
at the end, Chair?
Yeah, okay. We'll do both at the end, and that way I think that'll give us an opportunity. If there is any, if there are any points of discussion, we can do them then with a bit less pressure. Agenda item 6 is the rate is an SL1, which is a rates temporary rebate amendment order. Northern Ireland 2024. So members, the Department of Finance is proposing to make a statutory rule which will reinstate the back in business scheme to allow any business which occupies a long-term vacant property valued as a retail unit, which is a property unoccupied for 12 months or more, to pay vacant rates at the vacant rating level 50% for a 2-year period. Full details, can be found on page 26 of your meeting pack. So the proposed statutory rule will be subject to affirmative resolution. And I believe in the pack it explains that the whole point of this measure is that these are properties which are vacant, so that no one's paying rates on them at the minute anyway. So if you get in, you get a deduction, and the notional cost is 700 grand, I think, from the pack. But that's only a notional cost if there was someone in it occupying it at full rates value, but they're not. So if people are content with that proposal for the statutory rule to reinstate back in business, go to Jerry Carroll.
Just clarity to you, the clerk. Is there only a single rates relief on this? Because if I understand it, there's a rates relief for using the empty building, but if that's owned by another business, another company, can they avail of 2 sets of rates relief?
I don't think you can get double relief on a single property.
That would be my understanding, Chair, but you know what? I think it's worth checking to be absolutely sure, because the regime may have changed at some point, but I think that's probably right.
My understanding is you can't get double relief on the same property, so you can't get, for example, the manufacturer, the industrial derating plus, this, for example.
It's a one hit on them.
So people are happy with that department. Can we also ask, it might just be worth, given that it looks like, at 50%, there's a notional cost, but it's not a notional cost because it's one of these things where there's a notional cost, but it's actually creating some revenue, because it wouldn't happen otherwise. Is this have they looked at potentially adjustments to this under either the consultations, just because it might be interesting? There is that could be something where you're not actually cutting anything, but
just an additional clarification as well. If we can get a breakdown of who avails of it. I mean, I appreciate we might get addresses rather than names of organisations, but I'd like to get a sense of it. If it's small cafes, small businesses, it's one thing, but if it's big organisations, I'd have serious questions.
I could just suggest that we ask them rather than ask them for because there'll probably be a long list. So I don't want to. I'm happy to facilitate the request, but I don't want to. If it's like a kind of massive long raw data spreadsheet, we just get an indication.
They will have it. I suspect they have it in a particular grouped way. That's how they gather.
If they have it in to hand,
ask them how they do it and see where we go.
If they have it, what we could do is we could decouple the overall response from this data, but if they just have it to hand, that's fine. Okay, if members are content. So agenda item 7 is rates exemption for automatic telling machines in rural areas, regulations NI 24. The Department of Finance is proposing to make a statutory rule which will reinstate a micro policy within the rating system which applies a rates exemption to ATMs in a rural area. Full details can be found in page 32 of your pack. The proposed statutory rule is affirmative resolution. Members, are you content with the statutory rule and that would apply a rates exemption to ATMs in designated rural area, or does anyone require any further information?
Just a clarification again, Chair. I mean, is this, I understand it's rural ATMs, obviously, but are the banks exempt from the rates, or is it the companies that supply the ATMs, or is it the shops that is connected to it? I'm not really sure who's not paying the rates from my reading.
The banks don't necessarily own the ATMs. They're put in place usually by companies, but we can check the fine detail on that just to make absolutely sure.
I think this is not a tiny number. I can't remember the official said last week. I mean, it's not. It's a reasonable policy, but
it is, and there's a finite
like
number. Yeah,
And also, well, I mean, obviously, I know there's issues with people rurally and also even urban getting access to ATMs and banks, but I'd be concerned if it's again bigger organisations that are being exempt from rates, and ordinary folk are being asked to pay more.
It's worth happy enough that we invest with things. It is worth saying that if the pack says less than 50 grand as a cost, which is even in constrained times a less than a rounding error. But so happy enough for us to ask those questions. But we're talking about a very it's a relatively tiny intervention and small sum. But we're happy we can ask those questions. Grand. Okay. Agenda item 8 is the public pension. It's SL1. Public Service Pensions Revaluation Order. Members, the Department of Finance is proposing to make a statutory rule which will specify the change in the general level of prices or earnings used by career average revalued earnings public service pension schemes for the purposes of revaluing active members' pension benefits. Full details can be found at page 38 of your packs. So this is an annual thing that has to happen. This is an annual piece of secondary legislation. So the department has to it's effectively an indexation of pension, of public service pensions that has to be laid. The order for 2024 specify an increase in prices of 6.7% based on the published annual change in consumer prices index. The specified increase for earnings will be 7.7% based on the published figure for average weekly earnings. So this is subject to negative resolution. Members, are you content with the proposal for the statutory rule to specify the change in the general level of prices or earnings used by career average revalued earnings public service pension schemes for the purposes of revaluing active members' pension benefits, or does any member require any further information?
Agreed.
Okay. People agree? Fine. So the next SL1 is the Coronavirus Act 2020 registration of deaths and stillbirths extension order, Northern Ireland 2024. The Department of Finance is proposing to make a statutory rule which will remake Coronavirus 2020 registration of deaths and stillbirths extension order NI 24. These provisions allow for temporary changes to civil registration legislation to allow for electronic transfer of documents and registration of deaths and stillbirths by telephone. The full details can be found in the note at page 56 of the table pack. Can I just check, Clark, is this the same? Are we doing this for the next financial year rather than what we talked about this?
We got the information and this would have fallen. It's being remade until the end of March, and a further one will come for September. So after that, they'll have theoretically, and we'll get confirmation on this next week from NISR, they'll have the new vehicle in place.
Can I just confirm, what we debated before was the 2023-24
yes.
version. We're now on the 24-25, yes. Extending this for the next financial year.
This will only extend until September.
No.
This is the next. So this was due to expire on the 6th of March. So this takes it to the end of March, and there's a further. So it's 23-24.
Okay.
There's a partial extension then to September. So these always come in 6 month blocks.
Okay, so they maintain these until...
So this is just taking us to the end of March.
Yes, of course.
Then there's another one will go from March
to
September. So it's not annual, it's every 6 months on a rolling basis, March and September. So
18 days basically is what we're...
it was purely because of the nature of the way the date fell at the start of March rather than the end. So NISR will come next week and they can confirm that there'll be a new vehicle subsequent to the renewal to September.
So we will get in a few weeks' time then a March to September extension.
Yes.
Okay.
Chairman,
I can predict that Mr. Frew, strange it might, but not in the nice possible way.
At least I'm consistent, if nothing else, Chair. So the issue here is I have no problems with regards to the 2023 to 2024 to the 24th of March this year, okay? Because these have been extended over and over and over again. What I do take exception to, and I do believe it's unacceptable, is that what they're basically saying now is that the GRO proposed to use the time period provided by this remake, which ends from 6th to 24th of March, to then have time to bring forward a further extension of this legislative vehicle, which I find completely and utterly unacceptable. So I do believe that they should be using this time from the 6th of March to 24th of March to bring forward a new vehicle for which to have this procedure. I have nothing opposed. I'm not opposed to the procedure. I am opposed to the Coronavirus Act being used for this measure. And whilst we are getting the presentation from NISRA next week, and I acknowledge that, I have no problems allowing the extension up to 24th of March. But again, my party has been consistently voting down or voting against the Coronavirus Act extension. So that means that if they try to use the Coronavirus Act vehicle beyond March, and my party votes against it in the Chamber with regards to the Coronavirus Act itself, which comes from the Health Department, then they won't have a vehicle in order to extend.
So, does anybody else want to come in on this before we? We are going to get. You want to come in, Deputy Chair? Yeah, absolutely.
I just want to, just to follow on and support Paul's point here on this one, that, and just to build on it again, that, we accept the points and it's in the tabled papers and I've been through them in detail. The process of this registration, we support it, we accept the reasons for it, we accept the pressures that it takes off, the GP services. Yeah. But we do think that, I know there's reference made to the officials mentioning it next week, but the escalation and prioritisation of bringing forward another vehicle for this is something that we very much support and feel quite strongly about.
Okay. Someone else? Deputy Harger wants to
I think for me it's just the time scale. I mean, your point's well made and it's clear on what your position is. And obviously you don't want to keep rolling these things indefinitely, but I mean the 27th of March isn't far off, it's a few weeks. If it was possible to do it then that's all fair and well, but it may not be. But I suppose we'll come to that in a few weeks' time, and we'll have obviously NISRA next week to discuss it. But for me, it's the substance of what it is it's going to do. And if that needs to roll until September, if we can get certainty around that there's going to be another vehicle. But I'm assuming we'll come back to this point within the next week or two anyway.
Owen Tennyson, what's going on?
Thank you, Chair. I mean, this feels like Groundhog Day. I think we've had this conversation literally every single week we've come to this committee, and I don't think it's constructive or productive. I agree that we should have a standalone piece of current legislation to deal with some of these issues, but members can't argue on one hand that they support the streamlined process and then argue for a course of action which would jeopardise that. So we've seen this, for example, with the Department of Communities saying that they weren't going to proceed with the statutory rule around hybrid working in councils. Now that means that a number of councillors with care and responsibilities, with disabilities, and a whole host of other reasons why those councillors mightn't be able to attend those meetings are being disenfranchised. So I think we shouldn't be overly ideological about this, and we need to take practical steps in order to maintain the provisions as they are until that current legislation can be updated and put in place, which is of course the right thing to do. But I think members also need to be honest about the fact that ministers' interests are overflowing, and the expectation that we would be able to resolve all of these issues with new legislation in a couple of weeks is unrealistic, and also need to accept the fact that the Assembly hasn't been here for the last 2 years, and so that is why we're in the position we're now in.
Okay. Are there any other comments that people want to come in? Just in the interests, first of all, it is important to restate we do have NISRA in front of us next week. We will be able, when NISRA in front of us, to ask, is it Philip Wales is the official, to ask for explicit verbal and then follow up with written guarantees that we will have legislative, a new legislative approach or vehicle for solidifying this rather than cognizant of that. I am going to suggest that we that we put this. This is subject to confirmatory resolution. So I'm going to ask members if they are content that we are content with the proposal of the statutory rule to make temporary changes to the civil registration legislation, allowing for electronic transfer of documents and registration for stillbirths and telephones. So, if people aren't content, I'll put the question. If people are content, I will put the question, and obviously people are free to express dissent if they wish, and we can record the vote. That's totally fine. We can do that. So I will put the question to the Committee for Finances considered SR 2924, the Coronavirus Act 2020, registration of deaths, stillbirths extension order, Northern Ireland 2024, and subject to the report of the examiner of statutory rules is content that the rule will be approved by the Assembly.
So, Chair, those in favour of the motion, please raise your hands. So we have 1, 2, 3, 4, 5. Those against, please raise your hands.
Again, it's because it's the extension to the 24th of March.
Fair enough.
That's to me, it's not the issue.
We
We don't need to record a vote on this one, do we?
It's
just agreed.
yeah, it is agreed. It's just
If it's agreed, if people don't want to record it, that's totally fine. So we can just say if it is agreed, it's agreed. But I was just giving people the opportunity to put their as good order to put their views if they want.
Next extension may be different, Chair.
Well, absolutely, and you'll it looks like you fairly quickly have the ability to push that. But obviously we can all, and I think we would all want to get clarity from the department. So the next item is agenda item 9. I think we've got one more, Stephen, one more bit of SR. The department has made a statutory rule which will stipulate in legislation the regional rate for domestic and non-domestic property for 24-25. Full details can be found at page page 44 of your meeting pack. At the meeting on the 21st of February, members considered the policy proposal and received a briefing from the Director of Rating Policy. The Examiner of Statutory Rules has reported formally on the rule, and there are no matters drawn to the Committee's attention. The ESR third report can be found at page, so this is page 14 of your table pack. That's the Examiner of Statutory Rules report. The rules subject to affirmative resolution will come into effect the day after the day after the rule is affirmed in the Assembly. So this is the poundage. Basically, we are now. So where we came back before, we didn't. We were talking about the making the order, not the actual poundage. Members of their contempt of the statutory, I think Jerry Carroll.
Yeah, this is the increased chair, isn't it? Yeah.
Yes. This is the 4%.
Yeah, I just want to state our opposition to this. I mean, obviously it's a 4% increase, and there was a 15% touted, and it's sort of presented as something positive. But I think when you have your rents going up by at least 10%, and your food's been going up year on year on year, and haven't came down, 4% on top of a 6% last year is too much for people. Other areas and regions have frozen rates, and I think we should have been looking at doing that. Additionally, Chair, you've got record profits here, and we had a bit of that conversation last week, and you raised some of those issues about Amazon, like myself. So I think it's unacceptable that people have been asked to pay more. I think it's a false option as well to say it's either do nothing or increase people's rates. So I want to record my opposition. Appreciate it may be a minority of one, but I think it's worth putting your cards on the table in terms of your views.
Fair enough. Does anybody else want to come in and make a comment? No. Okay.
I don't think anyone wants to see people's bills going up, but if we're making the statement that we don't want to see a rise in that, then obviously people are then required to say what they want to see cut in terms of programmes moving forward. Government are only able to spend what money they have, so I don't think any of us want to see ratepayers having an increased cost, but ultimately we do need to fund our public services. We need to fund public sector pay rises, and to do that there needs to be the money in place. I think all of us around this table want to work together to maximise the money that comes across from UK Treasury so that we can fund our services. I don't think anyone's welcoming the fact that we're increasing bills.
Okay. For the purposes of getting people's, I think I will record a vote. I mean, I'll just put on the record from my perspective, like, I want to facilitate this happening as quick as possible. I don't anticipate this is going to be interrupted. I, in my political capacity, my non-chair capacity, will be recording an abstention on behalf of my party. We've been clear that we aren't, in the early days of this new mandate, going to get in the way of the new executive doing while registering our concerns about some of the processes around settling the financial settlement and some of the outstanding questions that have not been resolved, we aren't going to get in the way of the executive getting on with doing its business, though we do have specific concerns which I've recorded and will record in the chamber when we come to debate on it. But so I will just record a vote just so that we have it on the record, so that Mr. Carroll can put his vote against on the record. I think I'll just ask. I think I need to put the question and then do the division. Is that right?
Yeah.
Okay. So that the committee is so make sure that the outcome of the vote is properly recorded. Everybody. So if the committee is content with the rule, I'm going to put the question that the Committee for Finance has considered SR 2024-28, the Regional Rates Order Northern Ireland 2024, and recommends that it is to be affirmed by the Assembly. All those in favour, raise your hands, please.
So we have 1, 2, 3, 4, 5, 6.
All those against?
1, 2.
No, sorry.
And then
1 against, and then 1 abstention. Now, members, we are into. That is carried. Yes, that's carried, and obviously that will be communicated to the plenary, with the Business Office, and then the plenary debate next week. So, members, the next 2 agenda items will be dealt with concurrently, and the same departmental officials will brief us on both, just remembering what sort of some of the points I made at the beginning about us. Ideally, we'll get through some of these as speedily as possible. So it's the Procurement Regulations 2024 and the Trade Comprehensive and Progressive Agreement, the CPTPP. Yes, I thought I knew about trade stuff a bit, but anyway, I'm terrible at acronyms. Members, on the 21st of February, Sharon Smith, Chief Executive CPD, highlighted the committee would be dealing fairly soon with these procurement issues, and I should also, before I progress any further, seek agreement from people that Hansard record the next 2 items. People are happy enough, I presume you are. So as I said, sorry to go back, Sharon Smith, Chief Executive CPD, highlighted that the committee would be dealing with 2 important procurement issues: a statutory instrument regarding regulations flowing from the Procurement Act 23 and a legislative consent motion flowing from the Comprehensive and Progressive Agreement for Trans-Pacific Partnership Bill. Members, while the committee has subsequently reinforced these under the broad term of reference these under the broad term of procurement, they are separate items, and they will be briefed on separately and recorded as separate items on the agenda for the purposes of clarity and differentiation. For convenience, a clerk's memo found at page 52 will deal with both. So members, also included in your packs are DOF memos on the SI and the LCM request. For some reason, I'm finding this agenda item very difficult to read through, so apologies. As well as the CPTPP bill and procurement regulations and explanatory memoranda for both. Welcome Michael Watson and Paul Brown. Michael is procurement policy and performance from CPD, as is Paul. Officials, if you could brief us first on the procurement regs 2024 and then the bill. But can I ask, I know this is we have quite a lot on the agenda today, so I may interrupt rudely to it's not me being rude, but it's just to try and get questions in, and do please be concise in that context. I know it's a complex area, but they're both complex areas. So if you could do the regs first and then the bill.
Okay. Thank you, Chair, for the opportunity to be here. So where the regulations have come from is the Procurement Act received royal assent last October. The Act sets out a legal framework for public procurement, but within that Act there are many provisions and powers to take certain actions in the future, and the regulations are the first outworkings of that Act. Okay, so in order to make the Act work and to be implemented, these regulations are necessary to set out further detail. It allows organisations to understand what parts of the procurement will apply, because, as you've said, Charlie, it's very complicated in some of the application of it. Okay, but what I would say first is that these regulations are substantially the regulations that we currently have, but clarified and enhanced to deal with some of the provisions of the Procurement Act. So, much of the emphasis of the new Procurement Act is around transparency and public procurement, and there's a lot of good reasons for that in certain inquiries and things that have happened over the last few years during the pandemic and so forth. And substantially what the regulations are setting out is a range of detailed notices that are required to be published by contracting authorities across the procurement life cycle. It has become more detailed in our current regulations because the Procurement Act has a greater focus on transparency, and this is about publishing a huge range of information and different notices right across the procurement life cycle. And it's important to understand that the Procurement Act for the first time expanded the definition of public procurement. So the current procurement regime very much focuses on the tendering element of procurement, which is inviting tenders, assessing tenders and awarding the contract. But the Procurement Act actually expands on both sides of that. So before we actually go to tender, there's an awful lot of provisions around engaging with potential suppliers and markets to firm up our ideas, to try and get it right before we go to procurement. And very much welcome to everybody. It now extends into contract management, and there's a requirement on contracting authorities, particularly of contracts above £5 million, to publish key performance indicators and an annual update on those indicators. So much of this regulation is setting out the details, precise details of each of those notices, which is why it's so long. And it goes into infinite detail, like such as your name, your address, who you are, supplier, and so forth. Importantly, part of that principle is to try and open it up to smaller businesses by giving them more information. But one of the key features of these regulations, which powers set out in the Act, is the introduction of a new central registration and database, which is absolutely crucial for small businesses. This has been sought after since I've been around public procurement, which is quite an extensive period of time. And the idea behind this is that we're going to create a new register. All companies must register with it, and then they put their details in it, because at the very front end of all public procurement processes, there's a requirement to check a supplier's eligibility to make sure they haven't breached laws, that they have prerequisites in order. But what suppliers very often have to do is they have to give this information every time they actually tender for a procurement. This new database will allow them to store that detail, push a button, and that detail will be sent over to anybody that supplier submits a tender to automatically through an automated process. And that means not only will they not have to keep going through the rigmarole of producing that information, but all contracting authorities in England, Wales, and here will have that information. That will be consistent for the suppliers. So that's been broadly welcomed by the suppliers. The rest of the regulations actually set out some detail around retention of provisions that are in what's called the utilities contracts regulations. It's really specifically in relation to supply of electricity, heat and gas, because the money is provided by private sector organisations, but those organisations must still follow procurement rules when they go to award certain contracts. It sets a little bit of detail out in that. There are many schedules to the back of the regulations which set out the list of services that must be opened up to public procurement, and there's a distinction there. Some of these services that are opened up to public procurement are agreed as part of the negotiations of international trade agreements between the UK government and other countries. And there's a secondary schedule which is what's referred to as the light touch services, which are services mainly in health, education and cultural sort of sectors, which aren't normally part of international trade agreements, because simply they don't generate interest from suppliers in other countries, because you've got to be based here and rest of it. There is a part of the regulation that refers to the disapplication of Section 17 of the Local Government Act. We didn't need to apply that here because the power to do this provision is already in our Local Government Act of 2014, I believe it is. Really what happens is there is a provision that prevents local authorities from considering matters that are non-commercial in the procurement process. And that stops them from implementing many policies that we try to pursue in public procurement. So the power we've discovered in this exercise of working with cabinet office, we already have it, but we need to bring something forward just to disapply it in the Act. There's also some definitions in the regulations, because there's a distinction between a central government body and a local government body in terms of the application of procurement rules and different thresholds. And those are set out in a wee bit of detail towards the end of the regulations. And just to add that this was consulted on publicly last August. There were a number of responses from Northern Ireland stakeholders in both public and private sectors. Very positive about it. There was no real requirement for significant reform or refinement of the regulations. So that's probably a very, very quick overview of the regulations, but I'm happy to address any questions in relation to the Act as well, because that's where it comes from.
Yeah, I think that might be useful actually, because I think the key point is we'll do this first and take questions from this members, and then we'll go on to the trade agreement and the procurement bit of the trade agreement afterwards. And just to say on the trade agreement, we're talking about the procurement bit. I don't think it would be fair to get into there are lots of other trade agreement implications for that Michael and Paul probably shouldn't be liable to answer on. But just first on the regulations, we're effectively being asked to approve here regulations under Westminster legislation. The procurement regs are transferred here Is it a transferred power to make these regulations, or fully devolved?
It is transferred responsibility. However, when we were working through the provisions of the Procurement Act, the question arose of what powers we would require for Northern Ireland in that. In the absence of any sort of direction on it, we actually asked Cabinet Office to draft it on the basis of concurrent plus. So at that point,
What does concurrent? You're going to explain.
yes, I'll try to explain it. It basically means that we can still do our own regulations if we wish, or we can ask Westminster to do it forward if we consent to do it. And in this stage, when the regulations were being drafted last year, we needed to be included in this set because October is looming and there's a 6-month lead in. So these current regulations are going to be led next week, actually, in Parliament. If we had to bring our own regulations forward, one would be very resource intensive.
Yeah.
It would have to be a copy out of these regulations because we have to implement the provisions that are in the Act anyway. There may be some options around some policy matters.
Would it make it harder if it wasn't implemented? Would it make it hard? Would it make it theoretically harder for a business from here to bid for business in GB, or for example, or what would be the outworking of us not being in line?
Well, I think we need to clarify that the Act would require us to lay basically a copy out of these regulations ourselves.
We don't really have much choice. We don't have much choice. If we don't lay these regulations, we're in breach of an Act that's already passed and had royal assent.
Yeah.
Okay. So, but business, your constitution you've done has suggested that business are broadly content.
Yes.
Or do they? Yeah.
One of the advantages of it is that businesses bidding for work in England, Wales would actually be sitting exactly the same process, getting advantage of the central database, the registration system. So the procurement process would look the same, and an awful lot of our businesses do actually tend to tender for work in those other jurisdictions.
There was I think that the last time I took evidence from you in the previous committee, there was this slight potential issue about procurement legislation coming from Westminster post-Brexit, which was about basically having a thumb on the scale in favour of local suppliers, and there was a concern that that could discriminate against suppliers from here who are bidding for a contract with Derby Council or Liverpool Council. Has that been resolved?
It wasn't actually a piece of legislation, it was a policy. That Cabinet Office published shortly after we exited the EU, saying that local, they could restrict potentially procurement opportunities to county area, and they believed that wasn't discriminatory because they weren't discriminating on a national basis but on a local basis, and therefore they didn't. But as what we have is that the latest from Cabinet Office is that it wasn't really used because it wasn't very beneficial to local councils either, because for the sake of a boundary line you could actually be excluding one of your suppliers out because they fell 100 yards the other side.
Like lots of Brexit concert things, it's not particularly as good as it seems. Diane and then Paul Frew.
Thanks very much, and thanks, Michael, for coming to brief on this. Obviously, in the tight budget situation that we're in, procurement is critical. It's critical at any time, but whenever we're looking at our public spending, how much is going through the system and how much reported waste there is through inefficiencies and problems in the procurement system, bringing these regulations forward, it's my understanding from my reading of the detail, you're bringing together a lot of different older pieces into one to potentially simplify the process. Do you think that will help to reduce the problems that we're having within procurement and help effectively save us money?
It gives us the opportunity to do procurement in a different way. Okay, what we're doing is that there were 4 sets of regulations, which 95% were substantially the same, because there's only so much you can do in the procurement process. You have to invite a tender, you have to assess it. The advantage we're getting is from the Act, where there are currently 7 recognised different types of procurement procedure. That's coming down to 2, which is basically an open procedure which anybody can submit a bid for, and a flexible procedure that the contracting authority can adapt to get the best outcome. Very often we are accused of applying exactly the same commercial model, whether we're buying concrete or buying some kind of social service, and that doesn't actually work in reality. So what the Act will give us, it gives us time, it gives us the room and the opportunity to think differently, to bring different commercial models forward, and to try and get a better commercial outcome in the contract, and cut the focus off the process, which we're very much fixated with compliance with process detail, but actually sometimes we finish up with a contract that commercially is not the best at delivering value for money, or the best in delivering public services either.
Yeah, no, and I welcome your points on the transparency as well, because if you're publishing how you're spending, how you're getting on in the contract, it very quickly makes it aware to everyone, ourselves scrutinising it, and project managers, as to there's money perhaps being lost, and it gives us a chance to interact and intervene in that. Would that be your view?
Yeah, I mean, one of the objectives behind the enhanced transparency was for suppliers, but also for civil society to understand, you know, when we have large contracts and we have set key performance indicators when we awarded the contract, then we have a duty annually to at least go back publicly and make it available of how that contractor has performed, how the contract is performing, and how much money has been spent in that. Now, there is a part of the Act that would require contract authorities to publish payment notices, which is if you pay more than £10,000 in one go, you have to publish a notice saying, pay this supplier £10,000. We carved out of that in Northern Ireland because we couldn't see the benefit of that, because our contracts tend to be smaller, so any payments below £10,000, nobody would know they've been paid. So the Audit Office report last year has suggested that we need to come up with a better system to understand spend, and we're hoping to progress that through that mechanism.
No, that's great. Thank you very much.
Okay, thanks. Paul?
Yeah, thank you, Chair. I'll be brief. With regards to the register, do you reckon that will cut down the cost of tendering process for companies? And have you done any work on just how much that would reduce? First question. Second question is, with regards to transparency, will that lessen the risk then of court challenge?
On the first question, I think it'll bring a huge benefit to suppliers. I couldn't put a cost on it because every supplier's bid costs are different. But what it will do is, suppliers have been demanding this for many years, is that it will cut an awful lot of duplication, and not just the duplication of the paperwork, but the effort of trying to actually draw that paperwork into a tender will be removed. So I no doubt it will be huge benefits for that, and we're hoping to expand that database a little bit further to take some kind of information related to policy, and not just the stuff that's in the Act at the minute. Sorry, remind me of the second question.
Challenge.
Court challenge. It won't reduce court challenge because there is a right to access to justice, but what the Act has done is it has refined the areas of court challenge. There's a bit of a grey area at the minute of when exactly a supplier can take a court challenge. You can't challenge a contract authority until they've committed offence, which is basically at the point of contract award. What the new Act has done is broken it down into 4 areas to say that once the supplier believes that we have committed offence, they've got 30 days to bring that, and it kind of structures it into like a pre-tender phase in case we've done something in there, the tendering phase and the contract award. There is some further work being done by Cabinet Office with the courts in England to try and refine the sort of challenge process down into a more reasonable period of perhaps maybe 30 days to try and hear it and to try and shift it around. Now, we will obviously be watching very closely the outworkings of that project in England, and then when we see the findings, we'll try to present them here as well to say we should take some more action.
The other aspect then is the utility aspects of the bill with regards to electricity. So do we know yet how this will affect, if at all, the running of the ISEM, single electricity market, and then also the players within that? So you're talking about the same committee and you're talking about Sony, system operator, and then even how it will affect the utility regulator and their operational work.
It just means that when those organisations, if they're classified within the regulations, they fall into certain criteria, then when they go to contract for goods, works or services, they have to comply with the procurement rules the same as ourselves. That's all that this would.
So doesn't it actually affect the day-to-day running of the single electricity market as such when you buy units of electricity?
No, it wouldn't impact on the regulators' work. It's really just a matter of because there's economic interest from suppliers in other countries in relation to gas, electricity, utilities, transport, all sorts of things, railways. It's usually that those utility markets are part of the international trade agreements, and that's why we have to provide public procurement to them. And some countries are different. Some it's publicly owned, some it's privately owned, and there's a mix. So the best way to do it is to set a definition for that authority, and when it ventures into a contract for specific works in relation to that, then they have to open it up to suppliers from other countries.
Okay, thank you, Chair.
Okay. Jerry, yes, Jerry Carroll.
Thanks, Chair Michael. Thanks. Just 2 questions. I think this updates or clarifies procurement breaches, if I've read this correctly. Is it an increase in terms of penalties, or does it make it simpler, or what's the sort of delay?
The Act couldn't address penalties because that's calculated and it's taken care of within the court system. I mean, one of the distinctions that we have here and the court in England and Wales, which is the same court, is that when we launch a writ here, you just lodge a fee of £265 to take the challenge. However, in England, you must quantify the potential damages you're seeking, which means that the cost of the writ could rise to in excess of £10,000 just to get through the door of the court. We couldn't do that in the Procurement Act because that would interfere too much within the court structure and the justice system. But what it does is it sets a test very often when a challenge is first raised, there's a decision made of whether to set aside the decision in the first place. And the Procurement Act itself has set some criteria around how a test should be conducted by the court in judging set aside, and it concerns things like public interest in the public services and so forth, which the previous legislation didn't have. So there's some clear rules around it.
And just to clarify, there's no lifting the cap or increasing or setting out what a fine could or should be. That's done to the courts in terms of the okay. And then is there anything as read through it in detail, but it was quite hefty. But is there anything about state aid? Because obviously there's EU corporate and procurement law. It's quite sort of stringent for the most part of not allowing interference in the market. Is there anything in this legislation around making interference in sort of market affairs, so to speak, easier? Or I couldn't find that in the
not in the procurement side. It's more, there is different piece of legislation. It's more in the Department for Economy about how state aid is treated and how it gives suppliers an advantage in certain circumstances. So there are rules. It doesn't really drop into the procurement territory as I understand it at the minute. There was one provision in the procurement, the previous legislation, which was in respect of subsidies that was given by government to bodies to do certain works. It was mainly in the construction sector, and what it meant is that the money was transferred to a body it was really designed around PFI, PPP, then they had to comply with the procurement rules. Now that has been taken out because it was viewed that it was almost an anti-avoidance measure rather than being very proactive to let government get on with its business. So that's the only thing that's been removed from procurement.
Thanks.
Okay, thank you. I think that's everything on the regulations, Michael and Paul. We will move on now to the other bill, the trade.
Takes me a while to get it right too. It's a comprehensive and progressive agreement for the Trans-Pacific Partnership. It's quite a
and I've read a fair bit about it, but I can't.
Yeah. I get the letters.
We'll speed up as well if we don't have to say. So I'll just say, members, you don't have to read out the entire title of the trade agreement because it'll save us about 20 minutes if you don't. Go ahead.
I was actually to get the letters right, the CPs and the Ts. Right, please. So this is actually quite a minor issue. I mean, there is a trade bill working its way through Parliament that's nearly finished, and it does address intellectual property rights and technical barriers to trade, but are not our concern in the procurement field. So we're down to one clause which does affect transferred responsibility in respect of procurement, and that clause is simply to exclude from the coverage of the regulations any contracts or procurement processes that are wholly or mainly funded by international financial institutions. I've never come across one. And as part of this negotiation of trade agreement, the UK government has obviously agreed that if a contract ever come up with that nature of procurement, the whole suite of the current regulations, not the new Act or the 24 regulations which is addressed, the current one that's in play at the minute, wouldn't apply except any principles in regards to transparency, fairness and access by suppliers to that opportunity from other countries would be maintained.
So this is the one. So if I'm understanding, so members are understanding correctly, this is about getting an LCM for one particular bit of the bill that enables UK accession to this trade agreement. But the only bit they're asking for legislative consent for is one clause which changes, which updates which removes one type of procurement from the provisions of the bill, i.e. the trade agreement, and that is where the funder of the procurement is an international finance. What would that be, like the EBRD, like the European Bank of Reconstruction, that kind of thing?
And there's one other element where you must publish post-award the award value of a contract rather than range from the lowest to highest of the bids, but it's a requirement we already meet. That's a standard process for us.
So just so people understand, because it's important that there are many issues, concerns ranging from the post-Brexit landscape to other ethical issues people have with this trade agreement, but that's not really what you're asking us to come and to talk about here, or what the LCM is about. So just call it one. So are there any procurements that you're aware that are like that in Northern Ireland in recent? But would it cover? It would have to be a financial organisation. So, like for example, SEUPB would not be covered by it because that's not I know they're an grant awarding body, but they might theoretically do it.
There would be an international financial institution in regards to the comparison with the European Bank, which is different.
It would be like the European Bank of Reconstruction and Development or an OK. So it would have to be a financial institution. So the World Bank and the IMF would be, and there aren't any that you're aware of. Okay.
Never come across one.
So this is asking for legislative consent to update procurement rules to tweak some, because it's devolved here, or transferred, more accurately, not devolved, to change the rules for a theoretical procurement, which has never happened, as far as you're aware, in Northern Ireland.
Yeah, although it is going to change the current public contracts regulations, which cover England, Wales, and ourselves. We've never come across one, but that's not to say the other areas done that. Now they're going to have to change those regulations anyway to be able to exceed. So I believe the powers are there. If we don't consent, they will do it anyway.
So they will do it anyway. Now, can I ask first of all, the department's view? Is the minister of the department minded to give legislative consent? Number one, and then number two, does the department have a view more broadly about the procurement consequences or impacts of this, of the bill more generally, not just the narrow issue of the LCM?
We wouldn't be well placed to comment on the other aspects in terms of
Wouldn't be?
We wouldn't be. Now, what we can understand.
I'm talking about procurement bits now, not just like whether it adds to GDP.
The other parts of the bill are in releasing intellectual property and barriers to trade, which is not something that we'd be able to detail on. It really just is in relation to procurement processes. So simply, if we are asked to procure a contract that's funded by one of these institutions, then we don't apply the rules to. We still tender it, but we just don't apply the detailed procedural rules. The minister is currently trying to seek executive agreement to lay the legislative consent motion, and then we will come back to the committee on that. Okay. It's just that the timescale that we've been given on this is so tight. Yeah. I believe it's actually, since we provided the briefing last week, it's actually received its third reading in the Commons, and it's almost concluded. So there, the latest that we have from DBT, which is Department for Trade in England, is that they may not make royal consent before the Easter recess, but they'll certainly have it very shortly after that.
Bear in mind, this is the Sewell Convention, which has been completely trashed, introduced by the British government, and is effectively them asking for consent for something they're going to do anyway, and this narrow thing. So let's not, the idea that they actually care what we think, obviously has been completely disproven over the last. Not making comments to chair the Finance Committee, making political comments, the idea that they give two hoots has been utterly disproven over the last decade. But I wouldn't ask the officials to comment on that. Paul Frew and then anybody else. Sorry.
If I could just clarify on that one, the other administrations have had this since November last year. It's just that we couldn't go anywhere with it until 3 weeks ago.
Okay.
So they've already processed that.
Not to set off the chair, but I suppose this is very high level stuff which won't really affect us because it doesn't come down deep down dirty into our psyche of procurement. So very low impact, more technical than anything, but is there any sort of positive impact to Northern Ireland on their businesses and government? And the second part of that question is, if there's any positives, are there any negatives?
Again, I'm not best placed in the positives of the trade, but I know that in the letter we received there was an example quoted about a local company who export guitars into one of these nations, and it will help them because it will allow them to do that without trade and tariff on that. But outside that, I haven't seen that. Department of Economy would be more concerned around the exporting side of things. We just stick, unfortunately, to the procurement processes, and as a procurement body, we stick to the rules to do that.
Can you remind us again how many countries are involved?
I think there's quite a few. It's like
11 signatories until the UK.
Mostly Pacific countries, isn't it?
Well, the borders around. I mean, I think Canada would be one. Australia, New Zealand. Chile. Yeah, there's quite a few. Yeah. And there are also other trade agreements that were put through last year with Australia and New Zealand as well. So there's just different facets of trade agreements. There's many of them in the pipeline.
It doesn't make up for the 4% a year of lost economic activity from erecting trade barriers with the EU. But luckily, we are talking politically sheltered from some of that. I think that the two countries where there's additional trade access are Brunei and Malaysia. So if the Sultan of Brunei likes Vita bread and Tato, then maybe quids in. But I'm not asking you to comment on that because it's not within your bailiwick. If people are content, we will. Everyone happy? Any other questions on the Those regs. Thank you very much. Sorry.
We just wait for the process.
We'll wait for the process in the LCM and we'll discuss that. And thank you for coming to see us, guys. That was really useful. Now, we are about 10 minutes behind where we wanted to be, 10, 15. So we've now got and I really do want us to get to have a substantive chat with Fiscal Council. So the next item is the McCloud Judgement briefing. So members, the McCloud Judgement briefing starting at page 235 of the pack. And we've got officials coming in to see us. I think Colette Heaney is coming down from the Department of Finance, and Stephen Ball, we'll bring them in and they'll give us an overview of McCloud. Just a reminder, like, McCloud is really technical. I know I've said this umpteen times. It's definitely it's worth getting your head around. It's an important technical scrutiny issue we're going to have to keep working on, but there's no big political fallout on it. It's just a technical thing that needs to be understood, and there will be other opportunities to understand it technically should you need further briefing that can be facilitated. But Colette and Stephen will be able to give us an outline.
I just spelled the names right.
Yeah. Yeah, indeed. Yes, thank you, Colette and Stephen, for coming to see it. So, folks, members, at the last meeting, actually at the meeting before 14th of February, we agreed to get a briefing on the McCloud Judgement, which relates to legal cases taken by public servants following the movement from final salary pensions to average earnings pensions for public sector workers under the Hutton Commission report. I should probably declare an interest as someone who has a UK civil service pension, sadly long after the final salary pensions were ever a twinkle in my eye, but we're going to get an overview of that from Colette and Stephen. So Colette and Stephen, thank you for coming. At page 23, sorry, apologies, sorry, I'm on the wrong item. Page 235, my apologies. Page 235 of your pack is an update on the McCloud Judgement and a clerk's note on that. But I'll ask the officials to make a brief opening statement, if that's okay, Colette and Stephen, and then members can ask questions. I've said to members, if they want to follow up, we can facilitate further follow-up briefings, given the technical nature of the subject. Okay. Please go ahead.
Chair, I welcome the opportunity to brief the committee today on the McCloud remedy. You will note from the briefing paper that this is a complex issue. The paper attempts to cover the main background with all the committee members maybe not familiar with the overarching aim of the McCloud remedy. The Department of Finance has oversight responsibility for public service pensions policy and overarching legislation for devolved schemes, as well as direct responsibility for administration and governance of the civil service pension scheme. Members will note from the briefing paper that the legislation stage of the McCloud remedy has been completed, and the Department's focus is now on the implementation of the remedy for members in the civil service pension scheme in particular. By way of a brief overview, the 2015 pension reforms were based on the recommendation made by the Hutton Commission that active scheme members should move to a new career average or CARE public service pension scheme with pension age linked to state pension age for most public servants. The Commission's view was that final salary schemes had significantly increased in cost, and these reforms would make the schemes more sustainable and fairer across their membership and for taxpayers. The 2014 Assembly passed primary legislation to implement the pension reforms in broadly the same way as for equivalent schemes in the public service pensions in Britain. These pension reforms included the use of transitional protections, which were intended to protect the members who were closest to retirement age. However, the Court of Appeal ruling in England and Wales found that the transitional protections gave rise to unlawful age discrimination against younger scheme members and directed that they be remedied. Legal advice confirmed the transitional protections introduced for devolved schemes must also be remedied here. As the briefing paper sets out, the intervening period the legislation solution for the remedy has been put in place in the form of the Public Service Pensions and Judicial Offices Act 2022, for which the Assembly agreed legislative consent motions in November 2021 and January 2022. Secondary regulations for each of the devolved schemes have now been laid to ensure the discrimination is removed for the future and to address its effect on members since 2015. From the 1st of April 2022, all members of devolved schemes will only accrue benefits in the reformed schemes, removing any unlawful discrimination going forward. The committee will note that from the briefing paper that the local government pension scheme and the judicial pension scheme implemented protections differently. Therefore, the remedy for these schemes will be specific to these schemes. So the current focus and challenge for schemes is to implement the retrospective remedy. This means addressing the discrimination which existed between the period of the 1st of April 2015 and the 31st of March 2022, known as the remedy period. This will be achieved by providing each eligible member with an option to have their pension entitled for service during the remedy period calculated under either the pre-reform legacy scheme rules which existed before 2015 or the current reformed scheme rules. This is intended to, as far as possible, return members to the position they would have been in had the discrimination not occurred. Civil Service Pension Scheme, for which the Department of Finance has direct responsibility, has approximately 34,000 members in scope of the retrospective remedy. This includes around 11,000 members who have already retired. A dedicated McCloud implementation team has been established in Pensions Division to provide those who have retired during the remedy period up to the 31st of September 2023 with an immediate choice. The legislation requires members who have already left the service receive an immediate choice by the 31st of March 2025. Work is underway on the calculations required to illustrate the alternative benefits for these members. There are multiple interdependencies around these calculations, including the calculation of interest on any balances due, as well as the taxation of interest payments. The team, alongside our communications team, are also working on developing bespoke communications to adequately illustrate the options to help members make an informed remedy choice. Members who retired on medical retirement grounds, or alternatively, those who did not meet the medical retirement criteria under the rules in place at the time of the assessment, may require reassessment against the medical retirement criteria of the alternative scheme before an illustration of alternative benefits can be provided. Individual consents to conduct these reassessments have already been sought from those who have retired on medical grounds, and consent from those who did not meet the medical retirement criteria under the rules in place at the time of the assessment will be sought in the next few months. These reassessments will use the existing medical information which was available at the time of the initial assessment and will be conducted by the Occupational Health Service within the Department of Finance. These reassessments are now underway. From the 1st of October 2023, all eligible active members were rolled back into their legacy scheme, the pre-reform scheme, for the remedy period. Those retiring from the 1st of October 2023 automatically receive a statement setting out the remedy choice as part of the retirement illustration. All other in-scope active and deferred members of the scheme must also receive a remedy service statement by the 31st of March 2025, setting out the current value of their pension benefits in both the legacy and reform schemes for the remedy period. Going forward, statements will be provided annually as part of the scheme's annual benefit exercise. Considerable work has been undertaken on the design of member communications. The Department has provided regular updates to scheme members via pensioner newsletters, employee pension notices, and a dedicated McCloud Remedy page has been set up on the Civil Service Pensions website. No action is required by members until they receive the Remedy Service Statement. The brief set out on the projected costs of the adjustments to member benefits, that of £660 million, originally calculated as part of the 2016 valuations. The 2020 valuations have now been completed, and the reassessed cost based on the 2020 valuation assumptions is £650 million, so it has reduced. The civil service cost is now assessed as £140 million. Due to the changes made to the cost cap mechanism for the public service pension schemes, the 2016 and the 2020 scheme valuations will not result in remedy-related increases to member contributions. Pensions and payment are paid from annually managed expenditure (AME), and McCloud Remedy adjustments will be paid from AME when eligible scheme members access their benefits. Where departments make any additional qualifying financial payments under the terms of the remedy, this will also be classified as AME. Chair, to summarise, the necessary primary and secondary legislation for the remedy is now in place, and all public service pension scheme members accrue service in the reform scheme only. Individuals with responsibility for devolved schemes, including the Department of Finance for the Civil Service Pension Scheme, are now implementing the retrospective remedy for their eligible scheme members in line with the statutory requirements. Chair Stephen and I are happy to take any questions from the committee.
Okay, thank you very much. Members indicate to myself or the clerk if you wish to ask any questions. Are there any questions, Vice Chair?
Yeah, just a brief one. I was just wondering, in terms of scheme members, what's the feedback? Have they had a clear understanding as this process has gone on, or has there been challenges?
Most people are asking, when are we likely to get our choices? So from the 1st of October, when the legislation came in, those who are leaving the service are getting their choice right away. So that is a really good step forward, that people leaving as soon as the legislation come in are getting their choices. In fairness of the people who've already left, that's more complex. There are still some unknowns around tax issues, and that has taken a period of time to sort of understand and to finalise, and there's still some discussions between Treasury, HMRC and ourselves and DOF around how those will play out for the members who are impacted and are currently receiving their benefits, and the impact of tax. It's quite complex, and we're not tax experts. So what we have done is we're also working very closely with our government actuaries. So they have actually prepared a calculator of how to calculate the interest, because that's quite complex. And when we have fine-tuned the tax element, they will add that into the calculator to allow us to calculate the tax as well. So that's not finalised yet. So until that's finalised, we're not in a position to offer these people choices. What we also have done is that we have invited our internal audit in to review the processes that we will be using, and I think they're scheduled to come in May. And then once that they have talked us, looked through the procedures, made any recommendations, then we'll be in a position to start issuing documentation to our members around their choices for those who have already left. The clear communication that we have been saying to members is, you don't need to take any action until we contact you. And the legislative deadline is the 31st of March 2025. But in an ideal world, you would like to start processing cases and getting those out as soon as possible. But it's not doable at the present time because we don't have all the information, and it's not right that we give inaccurate information out to our members. But it is moving quite swiftly, and we are still doing the calculations in the background, so when things are clarified and we get recommendations from our audit that all is okay, we've done system changes, we're doing everything in the background to sort of progress things as much as we can. Okay.
Any other member? Jerry Carroll.
Thanks, Glad. It's very detailed, but I got a lot of that there, but obviously a lot more questions to go through my head. But just so I understood correctly, £650 million the total payments. Did you say £100 million of that has been made up by the civil service?
140 million.
And 40 million, and the rest presumably by the British government, by Westminster?
Well, that's specific to our scheme.
Yeah.
That's specific to our scheme.
Okay. Any other members who'd like to come in on that? Okay, look, Claire, Stephen, thank you very much, and thank you for making time. It's been a relatively brief session today, but I expect we will probably have other engagements with you, given the importance of this issue going forward. I don't know if there's anything else you want to raise with us or highlight to us in terms of our work programme going forward.
Well, we're happy to provide any brief any time, and hopefully the next time we may have progressed a bit further, but
yes.
I think we're making good progress, and there's lots of wee bite-sized videos on our website, and it keeps people updated as well. So, yeah. Okay,
well, thank you for coming to see us, and good luck with continuing rolling out the judgment. It's obviously complex, but really vital. Thank you very much.
Thank you.
Cheers. I don't think we have any follow-up. I will wait for more information from the team about whether how that's progressing. Okay. Okay, members. The next item is agenda item 13, which is a briefing from the Fiscal Council. There's a clerk's memo at page 249 of your pack. Also included is the recent publication which touches on the Executive Restoration Financial Package settlement, and there's some stuff in there about the previous Finance Committee's work on the Fiscal Council, including legislation. At the committee meeting on the 21st of February, members requested an update from the Department on the development of the Fiscal Council bill, and that can be found at page 23 of the table pack, and then also at page 25 of your table pack is a Fiscal Council report which just came out yesterday, which was an updated estimate of the relative need for public spending in NI, which is further sensitivity analysis, and that was published yesterday, and that's in the pack. So now delighted to welcome the Chair of the Fiscal Council and the Chief of Staff today, Sir Robert Choate, who's the Chair, and Jonathan McAdams, who is Chief of Staff. I know Sir Robert has to get away in about just less than 50 minutes' time, so we are, I think, you have hard finish at 4 o'clock, is that right?
Yes.
Is that correct? 4, okay. Well, look, thank you very much for making time. We've just about got here. We've hopefully decent time for a good set of questions, but obviously we'll be annoying you a lot over the next few years anyway. So we would like, obviously, the whole range of things, particularly I think starting on the financial package that we'd like to touch on, but also some of the work around putting yourselves on a statutory footing, and indeed, although it's very quick and slightly unfair, but given your respective CV, particularly Sir Robert's CV, I'm sure giving budget commentary is something at this notice is something you've a lot of it practice at. So if you've any views on that, we'd be interested to hear them. But if there's an opening statement particularly on the restoration package, we'd be keen to hear it and your views on it. Thank you.
Great, well, thank you very much indeed. It's a great pleasure to be here. Well, as I say, let me kick off with the package, and then I can add a very quick what I've gleaned on the from a quick phone call and a scanning of the OBR documents on the budget implications. Clearly, the package reflective of the not only the negotiations with the parties, but obviously the way in which the NI Civil Service has been discussing this over the previous months, has got a sort of two-pronged aim, which is stabilisation around the short-term budget crunch, reflective of the overspending against available resources over the last couple of years, and then a longer-term focus on transformation, or the ability to support public service transformation and moving to a more sustainable long-term position. So the package is made up of a number of different elements which are of greater or lesser importance in particular years. But essentially speaking, there's around 850 million of additional resource for this year, which is effectively very largely covering the backdated announcements on public sector pay, which have been made relatively recently. And then in the next 2 years, 24-25 and 25-26, there's a bit less, about 750 million, again very much predicated as short-term stabilisation support for the immediate public service needs. Thereafter, that drops away quite sharply to about 320 million in the following year. So that
26, 27.
27, 28.
Yeah.
So the initial upfront chunk of money largely drops away, rather than being, as it were, baselined and therefore providing a higher starting point from which the block grant is set thereafter. So that's essentially the short-term element of this. Chunk of money for this year, obviously largely backdated, 2 reasonable slugs of money over the next couple of years, and that's obviously helpful in the context, but by no means that balancing the budget over the next 2 years is going to be a walk in the park. It's a substantial contribution, but still leaves a clear challenge there. Then the longer-term component of the package is an agreement that, subject to negotiations between the Treasury and the Department of Finance over exactly how the methodology for this will work, that in future Barnett consequentials, which are the increases in the block grant that are provided here when the UK government increases spending in other parts of the United Kingdom on things for which the executive is responsible in Northern Ireland, under the way that normally works is essentially it's matched in pounds per head in the block grant increase relative to equivalent UK government spending. Henceforth, that will be topped up by 24%. That 24% is reflective of the estimate that you will have seen we produced last year as a broad brush estimate based on analysis that had been done to support discussions around the fiscal framework in Wales back in 2010 of what additional proportion per head needs to be spent in Northern Ireland to deliver broadly the same outcome from public services, reflective of the fact, for example, that the population is more sparse, more people in long-term sickness, more people in benefits, etc. So there is, plenty of discussion that it is possible to have over whether 24% is the right number, and we published a paper day before yesterday, which explores some of the variations around that. Personally, I wouldn't get hung up too much on whether it's 22, 24, 26, etc. The big difference is it's 24, not 0, and therefore the Barnett squeeze, that is called, which basically means that the addition to per head spending in Northern Ireland it gradually gets eroded over time. That squeeze is alleviated. So it doesn't get you straight away to a position in which the overall block grant is 24% higher per head than in Northern Ireland, but that builds up gradually over time. So what you've got overall is a package that's got, chunky upfront support and a valuable long-term addition to future block grant increases, which moves you towards a more sustainable position. The tricky point is between the two, when the short-term support runs out or is scaled down significantly, and before the impact of the Barnett top-up has time to get you back to where you started. So we've referred to this as something of a cliff edge in 2027-28, when the short-term money is reduced significantly. And in addition, there is the possibility that cliff edge could move forward a year if the executive does not agree some combination of revenue raising and other support packages. But there is clearly going to be ongoing discussion about that. So on top of all that, if I just briefly mention my understanding of the impact of today's UK budget on all of this, is that there is some additional UK government spending announced for the health service and for support for local authorities in England, which will generate £99 million worth of Barnett consequentials for Northern Ireland in 2024-25. That doesn't include the 24% top-up. So if and when there is agreement between the Treasury and the Department of Finance on the methodology, one presumes that would then be increased to something like 124 million. So there's that additional, and that's resource, that's day-to-day spending There is an increase in capital spending at the UK level, but as far as one can judge, that's not in areas that are barnetable, and therefore it doesn't affect the capital block grant. So there is some additional resource money in 24-25, but not on capital.
That's really helpful, thank you. And you've already answered one of my questions anyway on the whether the 100 million was included the updated needs factor. I've got a few questions, and I'm sure we'll have a lot of questions from members. So we should all try and limit ourselves, and then maybe we'll get if people have time, we'll get a second by the Terry. But just is it and Jonathan obviously come in as well if necessary. Just on a couple of your view of the needs factor that's been calculated, and you've done the paper. I think that the view of executive ministers has been that the package doesn't, and I think ministers have said this. The Fiscal Council believes that it doesn't meet adequately. Like 124 doesn't meet the needs. Isn't the correct needs factor? Is that your view, or do you think that it's more important to get it agreed, the timing agreed, or do you think 124 is enough? Basically, is that what you think, or?
Well, I think in terms of 124 as an estimate of what you need to spend in addition per head here relative to elsewhere, as you know, there have been a number of studies that have been done of that back to the point at which the Barnett formula was put in place in the late 1970s. They've tended to come up with numbers in the 120s to I think 131 was the highest in the
Treasury, which is unusual. You wouldn't expect.
Exactly, yes, but time has passed. Their view may well have shifted since then. Now, as I say, what we're trying to do is to follow as closely as possible, albeit in a broad brush way, the methodology that the Holtham Commission used when producing estimates for all the UK nations that then fed into the agreement in 2015-16 to put a floor under the generosity of the block grant for Wales. So we've essentially deliberately tried to get the same, as close to the methodology as they could. The plugging in more up-to-date data didn't give you a very different number from the 121 were they, or 120?
It was 121.
121 that they came up for Northern Ireland at that point. We've ended up with a central estimate of 124, and that's primarily because you're including additional spending on policing and justice, which wasn't devolved at the time, and obviously the Welsh the study didn't cover that for Wales. So there are so much uncertainties or different judgments that you could make to get you to a different number from 124, depending on the weighting that you put on different factors like the rural population, proportion of people who are long-term sick, etc. But then more particularly, how you estimate the top-up or the necessary top-up for policing and justice. And there, as we discuss in the paper, depending on which period of time you look at, gives you a greater degree of higher spending in the past, and it depends what you want to plug in there. So the analysis at the end that we came out with is that depending on how you try to calculate the needs requirement for policing and justice, how you stitch that on to the analysis that we did, essentially trying to mimic Holtham as closely as possible, could leave you with a number that is either higher or lower than 124. So we haven't, from the paper that we put out yesterday, now concluded that we'd now like to jump to a very firm view around an alternative central estimate. We're simply pointing out that you could make judgments if someone else was asked to do the job, which I would have no problem if they are, could end up with a higher or lower number. The value of this to the executive obviously depends in part on, as you say, the timing effects. So the way in which this is being applied is that the top-up is to new additions to the block grant. You're not taking the current stock of the block grant and increasing that by 24. So the crucial difference is that if you're starting with spending a little bit below need, and we don't unfortunately have concrete figures from the Treasury as to where they think that premium is at the moment, but for the sake of argument, if it's 120, then having this top up on new flows into the block grant, you will gradually rise towards 120 for, and the pace at which you do that depends not just on how fast public spending is growing at the UK level, but also on relative population growth. So there's a good deal of uncertainty as to how quickly you get to 124, on top of, do you think 124 is ultimately the right number?
There's a few questions if they've got to really resolve, is 124 right, and when do they get to it, and when is that agreed from? Difficult without the SR and a government about to probably leave office, hopefully leave office, he says with a political statement. Just on the 3.3 billion settlement, is it yours? There's been a bit of uncertainty with slightly kind of different accounts of whether the 3.3 billion includes reallocated money, or what the Treasury calls increased spending power due to certain, including like Fresh Start money, and obviously there's been an issue around integrated and shared education money that was ring fenced for integrated and shared education being part of this increased spending power. But obviously that means you're effectively telling schools that are literally procuring contracts and that they're not going to build or going to be able to build. From your perspective, is the reallocated money included in the 3.3 billion?
Jonathan, correct me if I'm wrong here. I think yes.
Yeah.
The sense then of, though, is this new money or not? You know, if it had been allocated in the past but it wasn't going to be spent,
yes,
then having something that is going to be spent is a genuine addition to resources, even though somebody in the past could have spent it already. So I think in that sense I'm correct in saying that, I mean, it's not double counting it. But it is reflective of money that was allocated in the past that wasn't spent, and this is some proportion of it, but we don't know exactly what the total amount. Is that right?
Yes, that's right. And there's also possibly money, if you remember the levelling up funding that may be rolled in, and the executive wouldn't have had a say in that funding.
Where that went, yeah.
So in a sense, that would have bypassed the executive.
These were because there were UK government packages that were agreed and therefore ring fenced, and they couldn't do it. Fine, okay, but it's just helpful to your view is that it was included. Just on this mooted thing, the Public Service Transformation Board. I'm still not entirely clear whether this has been finalised, agreed, and what its relationship is with revenue raising and all of that. Has the Fiscal Council been asked to give its opinion on or to participate in the Public Service Transformation Board?
I think it is a much earlier stage of discussion around how exactly that's going to work. I think, and again, Jonathan will correct me if I'm wrong, that the board is very much focused around the spending of the money that's been ring-fenced for transformation, which is actually relatively modest, about £50 million a year, rather than reaching a judgment on the coherence of the executive's overall financial package. So the question of, has the executive done enough on revenue raising, reform, other savings to prevent the Treasury from asking for 550 million back in 2026-27, I think that's ultimately a decision for the Treasury to take in discussion with the executive, not specifically one for the board. Is that, or is that just unclear?
No, I think that's probably right. We haven't been approaching that level of detail, Matthew. It's likely something that will come as part of that wider conversation about the framework. I suppose that's just guessing, but I'm guessing that that's going to be part of that wider discussion between the executive and the UK government about the wider fiscal framework.
Okay, great. I'm conscious that we are a bit of time, but we'll hopefully have you back in. So I'm going to go to colleagues and then Diane first, Vice Chair.
Yeah, thanks very much, Mr. Robert and Jonathan, for coming along today. And I just want to say thank you for the work of the Northern Ireland Fiscal Council, especially for me, the report in October 2022, where we had a period of a number of months where across the chamber here, it was widely stated that there were hundreds of millions of pounds in Northern Ireland that were being prevented from being put in people's pockets. And the Fiscal Council's report in October 2022 reported the £600 million overspend that we were likely to come to at the end of that financial year. So it was a very, very important report. And just to follow on from that, the independence and significance of the Northern Ireland Fiscal Council, to follow through from that, I wanted to ask what your view is on the legislation to support its independence.
Well, thank you. I think it's international best practice that bodies of this sort, and there are roughly 50 countries now that have independent fiscal watchdogs of one description or another, and the UK, Canada and Australia are all examples of ones that have both a sort of, nation-state level one, but also in the case of Canada and Australia for particular states and provinces as well. But in each case, having a robust underpinning for the legal underpinning for the body is important, and that tends to be around things like, in particular, the right of access to information from the government in question, that it needs to do its job, its right to be able to speak publicly about the things that are within its remit without, the danger of being muzzled by the government in question, normally safeguards around the way in which you appoint and get rid of senior leadership, and normally also around the transparency of the funding of the body itself. So having something in that space is a good idea to put that there. I have to say that the legal underpinning is an important foundation, but the success or failure of these bodies depends on good working relationships with all the stakeholders that you need information from and that you're providing information to. So it's a very important foundation, but it's no means sufficient for these bodies to function properly. So I hope we will be able to move to a model of that sort. I should say, though, that in the absence of legal underpinnings so far, I've accumulated a few bruises over the years in the past as I'm both an official and an unofficial fiscal watchdog and commentator. I think it's worked very well here. We have very good working relationships with Department of Finance, with the NI Civil Service more broadly. It's also been true when we've done, for example, work around health at the department there. We've been doing some work on infrastructure. So there really has been a very, good working relationship, and I've had no anxieties about not getting things that I need, and unless those things are not available. And that's been very welcome. It's also with these bodies. As some of the challenges confronting my former employers back in London, it's important that you have cross-party and widespread support, if not for everything you say on every subject, but there is widespread support for what the council is doing and for the value that it's able to that. And I've been very happy with the support and encouragement that we've received from everybody. I guess as it comes to sort of writing legislation, one thing I think it's important to be wary of, if you compare it to when I started with putting legislation in at for the Office for Budget Responsibility back in 2010 or so, is that when we were doing that, you knew pretty much that you have essentially a budget and an autumn or a spring statement. So the budget process was pretty clear and predictable, and you could therefore set legislation and associated memorandum of understanding that are based on the fact that you need a timetable for these events, you need information to inform them, and that choreography can work okay. I think it's important that if we have legislation for the Fiscal Council, that it is sufficiently flexible to reflect the fact that we've been on something of a journey during our time so far in terms of moving from having an executive, but one which couldn't agree a budget, to then having the caretaker minister period, then having Secretary of State, now back to a functioning executive again. We have necessarily had to interpret our terms of reference flexibly in the face of the way events have evolved. And so what I would slightly caution against in setting out the requirements placed on the Fiscal Council, it's important that it's clear that we know what we're there to do, but given the way in which it's a different task when there's a sitting assembly, it's a different task when there are negotiations going on, it's a different task when it's everything's being done from the Northern Ireland office. So let's try to build in a bit of that flexibility for the variety of possible futures we may all confront.
And the Minister said in the Chamber just last week about how she was working on the legislation development with yourself. So just wanted to ask what conversations there have been with the Council and Department of Finance, and what sort of timescales may have been indicated for progression of any legislation.
Well, I presume that the timescale is very much a matter for the Assembly as much as the Executive as to when you would take that. There was obviously discussion around the potential content of legislation, some time back with the civil servants in the Department of Finance, and that was very much focused on, for example, what could you take from the legislation that surrounds the OBR, what can you take from international standards. The sort of introductory conversation we've had with the Minister so far has reiterated that is seen as an important piece of work, but we didn't get into any additional wrinkles around the detail at that stage, other than that I made to her the same point I've made to you about be careful about making this too prescriptive, just in case we find ourselves in a slightly different institutional or governmental framework at the time we need to do the work.
Thank you.
Okay, Owen Tennyson.
Thank you, Chair, and thank you, Robert and Jonathan, for coming along. Can I just take you back to the level of the floor, the 124% that you're speaking to the Chair about? We had obviously expressed concerns that the 124% may not be taking into account the full range of policing and justice need in Northern Ireland, and I welcome the sensitivity analysis and the technical paper which was published this week in that regard, which highlights some of those issues in terms of the choice of the time period, and the fact that the time period chosen is the period where we actually have less than the recommended number of police officers, the security threat and other things. Is it fair to say on that basis that the 124% proposed by the UK government could well be understating policing and justice need in Northern Ireland, in your view?
Well, I think as with most of the analysis, it could go both ways depending on how exactly you look at it. I mean, one of the difficulties with the policing and justice of using the sort of methodology that Holtham used for other areas, where you're basically trying to find, factors, characteristics of the population, its age, structure, long-term trends in long-term illness, sparsity of population, etc., that are not in themselves determined directly by policy, and therefore they're kind of sort of independent variables that you can look at that would explain why you might need to spend, more on education because you have a population that's spread more widely, different numbers of people requiring more intensive support, etc. It's very hard to find equivalent sorts of variables to drive an estimate of what you need to spend on policing and justice. I mean, trying to pluck, numbers of convictions or, incidents of crime, it's not really getting at the sort of issues that we're really talking about here. And I don't think I'd be welcome, if anybody can think of any, that there are those sorts of indicators you could find from a census or a survey that would tell you that. So what you've ended up having to do is to fall back on inferring the need for spending from how much was actually spent in the past. And as you rightly point out, that can vary depending on the period you look at. So do you look, as we started off with a relatively recent period? Do you, as I think others have suggested, you go back to the period when the UK government was more directly in charge of this, but obviously under rather different security and political circumstances? Or do you basically take a longer time period to bring all of those things in together? There is no right or wrong answer to this. People will reach different judgments on that. The closest to having a sort of external variable to point at is, as you say, the analysis that we did based on the pattern judgments of policing need. But there again, and I'm not an expert on this, I suspect there was probably at the time debate over whether that was correct or not. And the fact that we now have, or the executive has, less policing than was required there, is that telling you that the executive has concluded that there's less need than that was implying, or that there's just not the money to meet the need? So at the end of the day, different people will have different judgments on this, and so I wouldn't say, having done that sensitivity analysis, that I would now jump very firmly on any other particular number. And obviously, some stakeholders, for obvious reasons, would like a higher number, and some would like a lower number, and perhaps in a predictable way.
Absolutely, thank you. And I think that points to the subjectivity around this, and about some of this is about political choices at the end of the day. So I'm conscious that the 124% that was published by yourselves in 2023 was somewhat illustrative for those reasons. Do you think there is a need for a body, be it yourselves or another independent body, to be tasked with actually making a policy recommendation on the correct level?
Well, you could. I mean, as I say, we were very clear when we came up with the 124 that it was relatively broad brush. We were trying to go as closely to the Holtham method as possible, but we said then, and have now obviously expanded more widely, the point that this, and indeed this is what Holtham said about his estimates back at the time, is that it depends on the precise judgments you make around these things. So you could, and as I say, I would not feel remotely, offended or miffed if the executive said we'd like to provide, somebody with a large amount of money to go away and do a much larger bottom-up project. I mean, Holtham didn't do their calculations on their own. It was technical quality. But what I would say is that sitting here now, I couldn't tell you whether, if you were to hand that task to somebody, they would come back and give you a higher or lower number than 124. The sensitivities that we have go to both sides of that, and as I say, you've had a succession of needs studies back to the late 1970s, which are essentially all in the 120s. So exactly where that ends up is you wouldn't know until they'd finished the work.
There is uncertainty. I mean, my inclination politically is if Treasury were willing to accept 124 gleefully, then perhaps the reality of relative need may be somewhat higher than Treasury are willing to suggest or accept. But no, thank you for that. I have two final questions. I'll ask them together.
We do have very little time. We've got 4 members still to get round, so I do want to be very quick.
Quick as I can. We've been told that the fiscal floor is a Welsh-style fiscal floor. Could you just speak to the difference between the needs adjustment in Northern Ireland and Wales? And also, do you have any inclination, and I know it's difficult to determine, when we actually fell below the 124% in terms of relative need?
On the latter point, unfortunately, what we don't have is a back series of what the 12x number, how that has evolved in the past on the Treasury's method of calculation, which will obviously then feed into how this thing is operationalised. Hopefully, around the discussion of how the methodology of this is going to work between Treasury and DOF, it would be nice if this discussion also resulted in the publication of a agreed back series of how this is performed. But our best guess was we were above need and that we've fallen through it relatively. And as I say, we've in the papers that we've produced put in an assumption that it's about 120. I think the Secretary of State made some statement referring to it averaging 121 over the last spending review period, so that's broadly in the same ballpark. When it comes to the difference between the Welsh and the proposal here, the key difference is that when the Welsh fiscal framework was agreed, the spending in Wales was higher than need per head rather than lower, which was the case when Holtham first started doing the work. So what you ended up having was a situation in which the Treasury agreed with the Welsh Government to put a floor under the premium of block grant over equivalent spending per head of 115. And in addition, while it was above 115, additional Barnett consequentials would be uplifted by 5%. So you had a floor and a mechanism that slowed the rate at which you fell towards the floor. What we have in this context, as I say, bearing in mind that the methodology has not yet been agreed, is that it appears that spending is starting below the needs level. And so therefore you have the top-up, which will gradually move you towards 124, other things being equal, and then it would stabilise at that level. So in some senses you might think of that as a ceiling. However, because the premium is also affected by relative population growth, you can actually go through. It's not a ceiling, and so you can go through it. And indeed, the projections that we produced in the report use the latest population projections that come from the Office for National Statistics, which shows that the Northern Ireland population is expected to grow more slowly than the English population and by a bigger gap than previous estimates suggested. And so that means that a given pot of money has to be spread, as it were, over fewer people in Northern Ireland than in England. So on that basis, a 1-2-4 top up to future Barnett consequentials will actually over time lift you through 1-2-4 as a total block grant compared to comparative spending. And I think the projections that we had suggested that that might happen in about 10 years' time, and then you would end up at something like 126, 127 over a 20-year time horizon. But this, of course, all depends crucially, not just on the population projections, but on how quickly public spending grows at the UK level. The faster it grows, when the Barnett formula is functioning normally, the quicker the convergence happens. And if you have spending cuts at the UK level, then actually in relative terms, Northern Ireland looks better. But is that something you'd wish for? Because you've actually got less money to spend. So it's a complicated story.
We need to be fair to the members. Deirdre.
Yeah, no, thanks very much for your presentation. I was going to raise some of the same concerns in terms of the needs factor and where we start, but obviously we don't want to be in a position where we're rounding down rather than rounding up. So it is something we're going to need to come back at. But just in terms of, I know you touched on it a bit there, in terms of the time scale where we could build up if there was an agreement. Now, we obviously need to get the data from Treasury, and that's difficult then because they hold all of that information and we don't. But it is, the 10-year period was put out, and that it might have been looking at the Welsh model. But could it be done quicker? Have you any indication or view on the timeline and the issue of backdating as well in terms of any discussions with the British government? The other issue, and I know you touched on it there in terms of some of that will depend on population projections and spend. So the impact of austerity over the last decade plus. So just your view around those issues, and likely, with some of the whimperings of the current British government, if they were to get back into power again in terms of restrictions on spending going forward, just the impact that would then have on the executive here and our finances. The other issue is in terms of even your view as well, in terms of the decades of underinvestment, particularly in infrastructure, and the impact that has. So if we're looking at a transformation plan, if we're trying to get on a more stable footing in terms of addressing those historical neglects, again, just a view or if any analysis have been done around those issues. And just lastly, because I think it is positive that the council was established, I think putting it on a firmer legislative footing is good. So it is to ask you out or beyond the terms of reference, because obviously it was set up, as you say, in very quick circumstances, and then that changed. What would you like to see as your role and remit going forward, if that is put on a firm financial footing, and would that be a lot more expansive than it is now, and if so, in what areas would you see your role?
Sure, thank you. There's quite a lot in that.
Just to start, I might move on to the next question after. Is that okay? Just
no, that's okay. You can do an end summary, whatever ways. Yeah.
On the austerity point, and this basically comes back to the answer I gave, what I've termed the Barnett paradox, is that in periods of austerity, Northern Ireland in relative terms does better rather than worse, but is that necessarily something you would wish for? So one of the reasons why the actual spend sort of fell through need relatively rapidly was when you started to see public spending at the UK level picking up again more quickly following the Brexit vote after, as you referred to, the earlier period of austerity when actually the spending was relatively high compared to need. So as I say, there's an element of be careful what one wishes for on that score. On the backdating issue, clearly you could design this in different ways that would get you to a 1-2-4 more quickly. One of them, which some people have obviously argued for, is to essentially take the short-term money that is being provided in 2025, 26 and 26, 27 and bake that into the baseline rather than taking most of it away in 2027-28. So, sometimes this is framed in terms of why don't you just imagine that the 24% top-up had been in place for the whole of the last spending review, then it would be incorporated in the baseline that you're setting for the block grant for the next spending review, and that would move you relatively more quickly. You could, in principle, say, why do we not just drop the Barnett formula altogether and simply say we will set the Northern Ireland block grant at 24% higher per head than equivalent spending in England, which would get you there straight away. That does, though, because there are different things that can move the premium. That wouldn't, that might introduce greater uncertainty around the sort of near-term movements in the amount of cash that departments have to spend. So it's not as straightforward. But there are certainly things you could do to get you to that position more quickly. In terms of the legacy of longer-term decisions on capital spending, obviously we for our next sustainability report, we wanted looking at some of the issues around water and transport, where some of those factors come into play. But it's hard enough doing an estimate of relative need for day-to-day spending than disentangling what the actual stock of capital is in transport, water, health, you name it, to come up with a robust estimate of that. But it's not impossible that someone could try that. Finally, on the remit. I don't have any urgent asks for things that we could or should be doing. I'm obviously, very interested to know what you and other stakeholders, whether you think what we're doing is a useful contribution, whether you think there are gaps there. I'm delighted that I don't have to do economic and fiscal forecasting as I used to have to do in the previous role, which is it's fun while it lasts.
You don't want to do that then?
Well, and this is reflective of the fact that the amount that the executive has to spend is not directly determined in the same way that would be the case at the UK level by the performance of the Northern Ireland economy, because there is only the regional rate as a domestically, generated and executive set source of tax revenue. So in that sense, obviously, if the Northern Ireland economy is doing well, that is great, both for the public goods and the private goods that Northern Ireland citizens can consume and enjoy, and you want, and that's devoutly to be desired. But it doesn't actually affect the amount of money that flows into the executive's coffers directly, because that is more dependent on what public spending is doing at the UK level. So there would not be any, unless you had a move to much greater devolution of tax and spending powers, for example, around income tax or something like that, in which case you then do move into the situation of needing to know much more about what's going on in the Northern Ireland labour market and also in the rest of UK labour market. But that's not the position that we're in. So I think I fundamentally see our role as primarily one of education, explanation, scrutiny, helping people understand their way through all of this rather than crystal ball gazing. And unless the policy environment were to change, then that's probably not necessary. Or if you do want to do it, it's not clear that the Fiscal Council ought to do it. There might be a question over whether there's a particular challenge of what should the role of the Council be in periods of negotiation or when the UK government is in charge of the budget. Again, our relations with, during the period that the NIO was setting the budget, they were very happy to talk to us on the same basis as the Department of Finance were. So I don't have any great itch I need to scratch in that area.
Okay, thanks. I'm just trying to get everyone in as possible. Keep
Thanks,
Jerry, Carroll, and then
I welcome the fact that there's now mostly widespread recognition that we're underfunded, because it wasn't always the case. Parties quite often say we need to cut things and do things better. So I recognise there's been a shift, and partly it's down to the public sector strikes and other things, but it's a welcome shift. There's been $500 billion, you maybe correct me if it's higher, $500 billion in public sector cuts in total since the Conservatives came to power. If you Barnettise that, if that's the correct framing of using Barnett, that would be probably in around several billion has been withdrawn from the block grant and services here. UK total wealth I think is $5 trillion. There's tax loopholes globally, $11 trillion in offshore accounts. The annual income of that is $850 billion. Crazy money. So that's a bit of a way. Robert asked, is the government looking at offshore accounts? Imagine not. But what, in your review and the Fiscal Council's view, should offshore accounts, wealth, taxes be looked at as a way to fund public services in the north, but also for people in England, Scotland and Wales as well?
I should just say, it's totally legitimate for a member to ask a question. It's not within the remit of the Fiscal Council. You've got someone who's very qualified to answer the question, but not necessarily in the context of his current role. So just to say, feel free to answer the question.
Should it be added to your remit?
Well, it comes back a bit to the previous point, which is there's not a great link between. Essentially, the block grant is determined or change. The block grant is a sort of partly a historical factor that you had the block grant as it stood into 1978-79, and since then it's been determined very largely by the Barnett formula, which is essentially saying when the UK government increases spending in England on things for which the executive is responsible here, roughly the same amount, pounds per head, is added to the block grant. In addition, you occasionally have the additional money from political agreements. So, Fresh Start, you name it, NDNA. So, in terms of if you were to have a larger tax raising exercise at the UK level, from whatever source, be that overseas taxation or taxing the domestic population, the impact on the block grant would just depend on how much the UK government was spending on that. So are they going to use the proceeds of those tax increases to cut other taxes, to reduce the amount that the UK government borrows, or to bear down on its debt? The impact on the executive here depends on the UK government's, not only how much they try to raise from those sorts of things, but what they do with it. And it's only really if they spend it on things in England that the executive is responsible for in Northern Ireland that there's that direct mapping through.
In order to get people in, I'm going to go to, although we will be able to see in today's budget, there's about $8 billion worth of non-done tax being raised and not that much money coming on public services because they're spending it on tax cuts. Philip, Brett, and then
thank you, Sir Robert and Jonathan, our fellow. It's great to see you here, and congratulations on your appointment. I just wanted to ask about your resourcing. Do you believe that you have adequate resources to do the current remit in which is expected of you? And would you is there anything that, obviously this committee I believe is very supportive of your work, is there anything that we can do in terms of further supporting you, including resourcing, but just want to see what further support the council and its staff may require?
What an excellent question that is. At the risk of taking the open goal and kicking as many balls as I can through it in a short period, to be fair, you can see the outputs that have been produced with the resources that we have, which we owe very, very much to the hard work of Jonathan and his colleagues, who have been absolutely fantastic. I couldn't have wished for a greater team to be supporting the council at a staff level. If we had more of them, or they were even more excitingly motivated than they are at the moment, we could be generating more outputs, of course, but we have to be aware of the context for the rest of the civil service and the rest of the Department of Finance. But I have not had to go and say what some fiscal councils in other countries have said. Look, our resources are just simply not consistent with the job that you are asking us to do, and sometimes that's a deliberate way of putting the squeeze on the fiscal council. We've been absolutely not in that world. If we had more resources, we could do more things, but I will ask Jonathan. I'm, as I say, very content with the staff support we've got. you could always use more of it, I'm sure, but it's consistent with what we produced.
Yes, that's fair. I would say what we've done, you might have noticed that our sustainability report is delayed, and what we've done is we've simply reprioritised. During that negotiation period, for example, we thought it was useful to get the UK government deal paper that we've done and some of our work on sensitivities. So we have just reprioritised. I think if things were in a normal steady state, we would be comfortable with that. But we are also generating things which we think are on top of our terms of reference, where we think that they're useful and interesting.
Thank you, sir.
Okay, thank you. Final now questions. Nicola Brogan, thanks for being patient, Nicola.
Thanks, Chair, no problem, and thank you to both of you for attending. Your expertise is much appreciated. I have two quick questions, and one is actually maybe more a point of clarity, Jonathan. From we were talking earlier about the 3.3 billion package and how the Fresh Start money has been included now in the 3.3 billion. And then you mentioned the Levelling Up Fund. And I know for the likes of myself, coming from a rural area who has suffered great losses because of the lack of EU funding, the Levelling Up Fund was really, really important there. Has there been any indication of it being brought back into the North, to your knowledge? And secondly, it's about the discussion really, I suppose, around the North having more fiscal powers, and I suppose fiscal responsibility with that. And what would the Council think, what powers should be devolved here to the North, and would then that have an impact on the sustainability of the North in the long term?
Yes, on the Levelling Up, there was money, obviously you'll be aware, there was money that wasn't sort of assigned to NI during the period where there was no executive, partly because there was no ministers in place. And so I suppose there's a question about that money. Is that part of the wider sort of fiscal package, and it may well be. If so, the point that I was making earlier on was usually what happens to that money is that the executive has no say over it whatsoever, so it bypasses the executive. So if that was part of this package, what would be different would be, rather than, if you like, a sports centre somewhere which the executive might not have wanted that funding necessarily, or maybe it wouldn't align fully, if it was actually included in the package, that would add to the spending power of the executive, because they would have control over it in a way that they wouldn't have done if it had come through the normal channels at the time. But I don't actually know. I don't actually know if that
more clarity on that ourselves, but thank you.
On the powers issue, obviously this was, when we were created, there was also a Northern Ireland Fiscal Commission, which was created at the same time, chaired by Paul Johnson, which looked at this area and came up with, obviously a discussion very much informed by what had happened in Wales and Scotland on potential devolution of some tax powers. It's not our job to say what should be adopted from that. I think the one point I would make is that it's important to bear in mind that if you were to have additional tax raising powers, say over a portion of income tax, that the block grant is then reduced by the amount that essentially the UK government is foregoing in revenue because you're collecting it and not them. And that introduces, obviously, the opportunity for the executive to have a more or less progressive tax system, to try to raise more money overall or less money overall, or to do things that try to influence people's behaviour. That's the things that a toolkit of tax powers allows you to do. But you'd also be taking on more risk. So the danger then is that if you're, and this risk has essentially materialised if you look at the comparison between Wales and Scotland. So both of them have additional tax raising powers, but Scotland has to some degree had to raise tax rates in order to stand still, because the amount that they've lost from the block grant has been greater than the amount they would have got from basically leaving all of the tax policies that they had taken responsibility for alone. That hasn't been the case in Wales. So where they've not had that underlying weakening in the revenue base. So I think there is a genuine political choice to be made here between, would you like greater ability to shape the structure of your tax system, versus are you willing to accept a greater degree of risk around the amount of money that the executive will have to spend on services?
Thank you for that.
Okay, thank you very much. It's also worth saying we have had, in fact I might raise this later on in the meeting, we do have an example of a block grant adjustment which we still pay for, £2+ million a year to pay for theoretical long haul taxes that do not exist, and may never exist again anyway, so we have to be careful what you wish for.
Stark but small demonstration of that risk.
But £2.5 million a year would it's given where we are at the minute. Okay, that's really helpful. Thank you very much. I suppose one final question from me. I think we're just awaiting your transportation. Is I think not quite with us yet. It's coming, so we are going to. So we'll stop. Pause.
It's very clear. You're holding it on until the cab is outside. This is exactly. This is very. We're now in this mode of kind of getting back to value. But one final question is just on the legislation point. I mean, your view, obviously, you expressed view around the need for flexibility to take account of the fact that, unfortunately, political instability here means sometimes we have institutions, sometimes we don't. Sometimes we have a budget, sometimes we don't. And so you need to be able to respond to those things so hard, like as in the Budget Responsibility Act basically assumes there will be a Chancellor who publishes a budget statement and a finance bill and that we can't unfortunately make that assumption here, so that you need that flexibility. But of course, that's been more complicated at the UK level since I left.
Well, indeed,
on
yes,
occasions.
yes,
as well.
on occasion, yeah, very much so. But just on the question about the legislation, would it be better, do you think, sooner rather than later? I mean, would you rather have it like this year or next, as opposed to at some theoretical point in the future?
Sooner would obviously be nice. It's much more important that it's the right legislation than it comes in quickly. I don't think, as I say, I've been, very pleased and struck by how good the working relationships are. So I don't see there being an immediate problem that we need immediate legislation to fix. But it's good international standards to have this sort of underpinning, and you never know. People could get more difficult at future stages, and having that there is important. But as I say, there is no urgent problem that requires it, within 3 months rather than within 9.
Okay, that's helpful. That is extremely helpful. Thank you very much, both Sir Robert and Jonathan. There, I'm sure will be lots of things we didn't cover today, but you've covered a huge amount for us. And so rather than detain you, I'll let you compose yourselves and have a glass of water before you have to hop in a taxi. We look forward to seeing you again in the future. Thank you very much.
Thank you very much.
Okay, thank you, members. We are going to move on now and cover the chairperson's business. Before we do, I was going to suggest I think it might be useful to get from the department just an update via the DALO, or whoever's standing in for the DALO, an update on the department's view of the timing for legislation. I just think that would be helpful for them to.
We do have a note on that.
Okay.
It's in the
pack. Okay.
We'll get to that.
Have they updated?
Chairpersons and matters.
Have they updated us? Okay. There you go. Then I'm going to update myself.
Not putting a time scale on it.
That's impatient. Okay, fine. We'll come on to that. That's useful to reprimanding myself then. Great. Okay, we're going to go back to chairperson's business. We have a few bits and pieces to work through. So item 1 is WMS written ministerial statements on a cash advance from the NI Consolidated Fund. On page 7 of your pack, members, you will find a copy of the written statement from the Minister regarding a cash advance from the Consolidated Fund to the NI pension scheme, which was made on the 29th of February and emailed to members. So members, that is for people to note. Unless there's any comments. So item 2 is WMS on executive agreement for regional rate setting 2024-25, page 9 of the pack. Members will find a copy of the written ministerial statement from the Minister regarding the regional rates uplift for 24-25. This was made the 29th of February 24. Obviously, it's going to be debate. We talked about it today and voted on it, and then we will be debating it in plenary next week. So we're asking members to note it. We've already considered the statute. I was going to suggest under chairperson's business then make a comment first and then suggest an action, which is I think the WMS, welcome though it is that it came promptly after the executive meeting, I was concerned that the WMS did not, it wasn't explicit about the percentage uplift. It then mentioned inflation, but didn't say which measure of inflation it was using. So I think good practice. Now it may have been that it was written at speed, and that's perhaps understandable. But I think basic good practice. We should ask the department to include in written ministerial statements an explicit reference to the percentage uplift they're talking about and which measure of inflation, because the WMS didn't say either, and I don't think that's good, to be honest. So I think if we can raise that with the department, that would be useful. Okay, so item 3, actually we have a couple of other bits of chairperson's business I was just going to raise. One is on what we've just discussed, which is on air passenger duty. Just because it's come up, it's putting me in mind of what's in the budget statement, which we haven't had a chance to go through it. So we obviously touched on it a bit with Robert Choate, but there are various bits in there. I wasn't aware until he said that the 24% is not included in the Barnett consequential we're due to get. I didn't know that, so that is concerning, and it's concerning because it indicates that there's a degree of we're not going to be funded at need, even in the kind of based on the provisional agreement we have. So it would be helpful, I think, if we wrote to the department and got their sense of the consequences of the budget statement in a number of regards. That first of all, is probably the most obvious one, the 124. Or the 100 million that we're getting, not the 124 million that we should be getting, based on what they've already agreed to, and whether their view is if there are further in-year consequentials this year, that's when are we going to start being funded at the 124, given that it has been agreed in principle. There's also a question, and it is important. I have Mr. Frew, who was in the previous committee, will remember I was a bit perennial on this, which is the subject of air passenger duty block grant reduction. For those of you who aren't aware, we pay £2.5 million a year to subsidise long haul flights out of Belfast, which I don't think at the minute, I could be corrected, so I'm happy to be corrected, but I don't think there are any at the minute, and there haven't been for a number of years. I think that's not, even though it's only £2.5 million a year, I think now in the budget document there is a change to APD. It would be helpful to understand if the department thinks that's going to affect the block grant. Even if it's a small amount, I think it's important to, do they know whether that'll affect the block grant reduction? It slightly varies year by year. It's usually about £2.5 million. That would be helpful to find out. And then I guess additionally, any other update they have from their view of the budget. If members are content, I just think it would be helpful for us to write. And obviously we are still in contact with the Treasury, and we'll await them confirming whether they're going to give us evidence, and we'll come back to that at some point. Okay, so Interparliamentary Forum is the next item. So members, at page 4 of the table pack, you will find a joint statement of the 5th meeting of the Interparliamentary Forum, which took place on Thursday, 29th February. And I was attended by myself and the clerk. It was a genuinely very useful meeting. The purpose of that meeting is for chairpersons of relevant scrutiny committees in legislatures, Scotland, Wales, the North, obviously Westminster, to engage on issues of common interest, specific common policy interest, one of which is the common frameworks, which is the kind of post-Brexit agreement on rules in different jurisdictions. There was a very warm welcome. I was there with Paula Bradshaw, who chairs the Executive Office Committee, and the clerk of that department, and obviously Peter, our clerk, joined. It was very useful, very constructive. There were some very interesting insights and also a commitment to work together. There will be some EU exit related things for us to discuss in this committee and in the TO committee. Obviously, the bulk of the work on the new regulations and scrutinise them will be in the Windsor framework, the Democratic Scrutiny Committee. But it was a really useful opportunity to attend that and build relationships. So thank you to the clerk for his work in facilitating that. There is another meeting which I think neither myself nor the Vice Chair are able to attend, but it is still useful for us to attend it. It's the Interparliamentary Finance Committee Forum meeting on Thursday, 21st of March. So our proposal is that the clerk attends that and feeds back to us if people are content with that. More will get done probably with the politician not there, but in any case. Grand.
Scots and Welsh will be there anyway.
Absolutely. There's like a run into the... Well, usually it's the Welsh are left out of the Englishman, Irishman, Scotsman joke, so perhaps it gets a bit more inclusive this time. Anyway, item 4 is the executive restoration package and the breakdown of 708 million. So that is in page 7 of your tabled pack, which came through yesterday. So the Vice Chair, Deputy Chair had an informal meeting yesterday. Unfortunately, due to a personal appointment immovable, I couldn't meet it. But thank you to the Minister for facilitating it. The clerk has tabled a hard copy note which is in front of you of the meeting. I don't know if the Vice Chair, Deputy Chair wants to feedback or give her views on the meeting.
Yes, it was very good of the Minister to meet and just share an update. It's quite positive communication chains built between the Finance Minister and the Chief Secretary to the Treasury, and there wasn't a lot more than is in the letter and in the hard copy note, but it's good that flexible conversations are moving forward in terms of our finances.
Okay, we will hopefully get at some stage soon an update. I'm not sure there's a further letter needed at this point, but it would be obviously helpful to have an update on. We'll let Paul Frew
Can I ask just on the back of that? We have the letter from the Chief Secretary of the Treasury to the Minister, and then we have the Minister's response. Is there additional correspondence yet that we have yet to see?
That's a good question.
Request in for that, so we'll wait to see what response we get. And also the Minister's up next week and has indicated she'll do further update on because there's ongoing meetings and discussions with the Chief Secretary of the Treasury also, and she'll update on budget process as well. So if we haven't got it in the meantime, it's an opportunity to ask the Minister directly.
But I think the note confirms that. One question I will want to ask the Finance Minister is she has been indicated on the floor of the Assembly already that it will be difficult to produce, if not challenging to produce a multi-year budget in the context without an SR, but it looks like from this note, multi-year budgeting may not be in prospect for the next few financial years, which I think is an interesting development. I know this is just a note from the meeting, so I don't want to put words in the
that would be in
mouth.
the context very much of what the next UK government does.
Yeah.
If there's a comprehensive spending review, that may well take some time before a multi-annual budget can come after that. So that was really written as an estimate of if that change of government happens and they do enter into a full CSR rather than just do a small scale review, then that would automatically delay the ability to run a multi-annual budget.
Yeah, again, Chair, whilst we'd like to see get to the point where we're in multi-year budget terminology again and environment, again the two cycles aren't compatible at the present time, so it's just not going to materialise, unfortunately.
Indeed, they aren't. But obviously, we need to get to a position where we're able to do long-term planning, even if but anyway, that's a slightly separate point. Okay, I don't have any further actions unless any members want to comment on either of those things. Right. Okay. We now need to go. We're sort of jumping around our agenda, so we're going to matters arising now. Page 6 of my pack, page 21 of the meeting pack. Members agreed to seek information from the department on the NI Consolidated Fund and how it can be used by government departments. Members ask you to note this information in advance of the departmental learning session next week. That session is going to examine the Consolidated Fund in greater detail, as well as providing members with an overview of the budget process, with particular reference to the meaning and rationale of key points in the cycle, including the spring supplementary estimates, the budget bill and vote on account, the main estimates, the number 2 budget bill, the January, June and October monitoring rounds. We've already been through a couple of these already, the budget bill and the vote on account, so we'll be able to have to understand them, having already voted them through, which tends to be the way with budget processes in the Northern Ireland Assembly. Okay, members content that we share that note with other statutory committees? Grant. Item 2 is residential properties at Victoria Square, Belfast. Now, I should declare a constituency interest in the sense that, first of all, this is in my constituency, and I have engaged with the interested parties on this. But at a meeting on the 21st of February, members agreed to send correspondence from an individual regarding the Victoria Square residential tower to the Department of Finance for to raise a number of issues, including clarity on which department leads on. And this is to do with what's called a limitation order, I believe. The correspondence has also been sent to a number of statutory committees, including Justice, The Justice Committee has agreed to write to the Department of Justice, the Executive Office and the Committee for Agriculture, Environment and Rural Affairs. Department of Finance officials have advised that civil law colleagues received an email from DOJ in which it was suggested that the committee should note that in light of ongoing litigation, this matter is sub judice. Officials also confirmed that this is an issue for DERA, so I ask members to note this correspondence. Okay, and if people are agreed, we will get the clerk to write to the correspondent on this issue. Excellent. Now, I think we've already done our. We're going back to correspondence. Yes. 14.
Page 17.
So, members, at page 582, there are 3 items of correspondence for you to note, we'll draw your attention to all 3 of them. Item 1, the first correspondence is the ISNI delivery tracking system, and that is from the department. Members may be aware these reports are published on a monthly basis with a view to collating up-to-date information on the status of projects and their underlying investing activities. The information is also publicly available through the ISNI website, which is used to provide the construction industry with up-to-date information. So the one that's most interesting is Orchard House, which has an amber status, and if members are content, we will seek an update on the refurbishment of Orchard House. So the committee's been copied into correspondence from the Minister as an individual on progressive wealth tax. So if members are happy, we'll note that correspondence. And page 586, we have correspondence from the clerk of the Public Accounts Committee on the on primacy and on the question of the Audit Office report on public procurement. We talked about this, I think, a week or two ago. The report was published in April 23 and found the current structures and arrangements have not provided effective leadership, governance and accountability in public procurement. We did talk about this, if people remember, with Sharon Smith. PAC has primacy over NIAO reports and will be embarking on an evidence session with Department of Finance officials. Seek members' agreement to indicate to PAC that this committee will wish to follow up on that committee's inquiry and recommendations. I don't know if it's worth, just as a matter of good order, to flag to them the Hansard of our evidence session with the relevant officials. Okay, members, agenda item 15 is the draft forward work programme, which is at 589. And so it's there. Obviously, as always, it remains a moving feast. Next week, we have a movable feast, not a moving feast. I think you can say both. Yeah, if it's movable, if it's moving, then by definition it's movable. We've got a ministerial briefing, so the minister is going to come and give us evidence. So we will have an opportunity to ask her a range of questions. So in a sense, we'll be able to get updates on a variety of things, including the restoration package, ongoing work around preparing a budget, whether multi-year or single year, and anything else people want to get on the record or want to discuss. We are also going to have a briefing from NISRA on what we discussed earlier on around the methodology questions and how that is going to be updated and regularised. So that is that's on the 6th. Are we the following? We're in recess then after that.
Yeah. So, Chair, we have the next 2 meetings, the 13th and the 20th, that we're scheduling into the Senate chamber. That's just easier when we have a ministerial briefing. We'll also do our collective photograph then, because it just looks better. And we may do a little bit of time shifting. Next week, we'd originally looked at the learning session from 1:30. We might actually move that to 1 o'clock. The reason being, I think we'll possibly look to see if we can schedule more time for NISRA in light of the conversations we've had today, which will mean just shuffling things slightly. The week following, we'll be starting another learning session with Raise from 1 o'clock. That'll be spring supplementaries. The other thing advertised for that week had been the monthly outturn. The committee always gets a briefing around that. What we might actually do this time round is we get the papers on that, but in terms of, if you like, starting at a logical point, if we wait till the following month, we can do the full year. Yep. So it'll be the actual final outturn, and then we can get a specific briefing encompassing what's happened across the year. It just means, rather than starting at the last bit of this year, it gives us a cleaner start. Also, we can get a briefing on round 13, which is
a boxing match.
No, it's the arms length. That's why I was waving my arms. That was my cue for the arms length bodies, which is a new thing. Members from the previous committee will recall that the new arrangements that came in 2022 around financial reporting mean departmental accounts now will include arms length bodies, but also that's where round 13 comes in. So I think it's likely to be of considerable interest to the committee.
Can I suggest that we, just to correspond early with, if we're getting the monthly outturn is going to be Joanne McBurney, and then Joanne is also going to give us an update on the spring supplementary estimates. Can I suggest that we, if members are content, that we also ask for an update on both the financial package? I don't think it would be that team working on the fiscal framework negotiations in all probability, but it would be helpful to get an update on where they are in terms of understanding the financial package, because it seems like it's still unresolved, and so I think it would be helpful if members we could also ask about that, and where those discussions are, and also the questions about budget processes basically, and whether we can obviously ask the Minister next week, but we have clarity over when and how we're going to have a budget statement and absolute confirmation that it's going to be single year.
Yeah, that'll sit quite neatly with the briefing around the spring supplementaries, because that'll get us into a kind of range of where else the budget process will head.
Yes.
I just wanted to ask next week, how long do we have the Minister for?
Minister has given us her afternoon.
Oh, has she? Excellent. I just wanted to know, in case we had to be concise in terms of allocating out questions, just with it being tight today, I was just minded to that. But
we'll have a discussion to make sure, like as with today, I think it's important that we are, like, when we do have limited time and evidence people, that we try and be respectful of one another, and we obviously want to make points. Some of them will be, sometimes they'll be political, sometimes we want technical things, sometimes we want to clarify policy things, but it is important that we are as respectful as, and I will, and I include myself in that we're as respectful and accommodating of colleagues as possible. But if it's good, if the Minister is able to give us that time, that's extremely helpful. So then I would say that we, obviously don't want to, if we have an Israel briefing, we'll want a time.
We'll try and make those timings work. I think that's probably where we'll look to maybe start earlier.
Understanding the fact that there is a very particular, members have particular interest in that, in the Nisra thing, I think that my view, the public will also have probably will want us to make sure that we're maximising our time with the Minister and giving her kind of, as it were, primacy in that regard. And then obviously next week we have the officials, and then we have our, after recess, we are due schedule, but obviously it might change with an update on next HR.
We're hoping, because that has evolved slightly, and Mr. Free wants to come back.
Okay, sorry.
Just the HR has evolved, so the roles have split, so we're having Jill and Catherine coming up to talk about that, because one is specific to tight end NICS reform, the other is part of the transformation more widely. Okay. So that the roles are just more complex now, Mr. Free.
Okay, Paul.
You might be glad to know that for me the NISRA presentation was always more about the methodology of recording excess deaths and the changes, the fundamental changes they've made in that process. The other part with regards to coronavirus legislation just came about nearly by accident, because we've been told that they are the ones now that's actually doing the work, which seems to me to be bizarre in the first place. So for me it's more important with regards to the methodology around the excess deaths.
Okay, that's fine. Any other comments that people have enough for the forward work programme?
Just send out in an email, just clarify the times then, just so that we know.
We'll get that done.
If it's moving to 1, is that 1 to half?
That's what we're looking at, is moving to 1. So Senate Chamber next week and the week after, if you sort of put it in your diaries for 1 o'clock each time.
But can I just say that for members, the 1 o'clock's the learning session?
Yeah, 1 o'clock's learning session.
It's not you.
But is the committee going to start at half 1 or 2?
We're looking to start at half 1, but we'll make that We'll make that firm.
Yeah, that
We'll make it firm and make sure it's in people's diaries and that it's clear. And obviously it'll have to be clear it will need to be clear for the public as well, and for people who might be watching externally. That's why if that could go out, and I think it's a reasonable point, if that can go out in official channels, so people, because there will be people who just, like any stakeholders, media, whatever, who will just assume it starts at 2 o'clock as normal. So if we are moving it forward, we will confirm that and communicate it publicly. Grant, if there's no other comments on the draft forward work programme, we will move forward to any other business. If there's no other business, then I will just confirm the date, time and place of next meeting is Wednesday 13th of March at 2 p.m. in the Senate chamber.
You're going to
Or
clarify.
1:30. Or 1:30.
Or 1:30, of course, sorry, yes.
We'll see.
I'm getting confused with the end of my chair's
I
note.
understand it.
Don't worry, yes,
We're
okay.
very live on this forward.
Yes.
Definitely the Senate chamber. It's definitely the 13th of
Definitely,
March.
and it is, yes.
Okay.
The date
Later on
and
in
the
the
place
Date.
are absolutely right.
Okay, we have the date right. There might be a slight change to the timing, which we will communicate clearly to members and the public. Okay, if everyone's happy, we will. The committee do now adjourn.
Thank you.